Hello, Ulf, and greetings from Australia. And sorry this presentation is a little bit later than I said it would be. So today, as I mentioned, I'll be talking about an important Australian case with regards to ISP liability. So the specific case I'll be talking about is the case of Roadshow Films and iiNet Limited, which I'll just refer to as the iiNet case. And the title of my presentation is Roadshow Films and ISP Liability, Answers and Ambiguities. Apologies, I tried to figure out a way that I could talk over some slides that I recorded. However, I wasn't able to do this, so I thought I'd just hold up some physical slides. I'm sorry if this diminishes the impact a little bit. So the subtitle of my presentation is Answers and Ambiguities, because the case provided a lot of important answers about how statutes passed in the wake of the new millennium would be able to be applied to the issue of ISP liability. But also the fact that the case left a lot of questions or ambiguities about how other laws should be applied. So here's an outline of my presentation. First of all, I'll be looking at the legal background of the case, so the laws that were passed and how they would then be applied to the case. Secondly, the facts of the case, so who the parties were and what they had at stake. Thirdly, I'll talk about the decisions that the courts actually came to. It's worth noting in this situation that the iiNet cases were effectively two decisions, so I'll talk about both in turn. And finally, I'll talk about what those decisions mean to ISPs looking to avoid liability, and also some questions or, again, ambiguities that ISPs would probably have to address when trying to avoid liability as well. So first of all, the background of the case. So the iiNet case came at the end of a large raft of legislation that was passed, which very obviously updated copyright law for the digital age. So specifically to ISPs, it updated the idea of authorization. So I'm now going to take you through what authorization means in the Australian legal context. So authorization is actually contained in the Copyright Act statute in 36.1 and 101.1. It's worth noting that both of these sections are interchangeable. They're effectively duplicated versions of the same section that refer to different kinds of copyright. So to take 36 as an example, it says that there are two kinds of copyright infringement that can take place under the Act. The first kind is where someone directly does an act that only the copyright holder is entitled to do. But the second kind is authorization, so where you authorize someone to do such an act, and that itself counts as copyright infringement. But what does authorization actually mean? So what does a party have to do to authorize copyright infringement? Well, we actually have to turn to case law for this, and the important Australian case of Adelaide Corporation and Australian Performing Rights Association. So this case is very old, it's from 1928, and to take you through the facts quickly, it involved a concert hall owner who was found to have authorized the copyright infringement of a singer who was performing songs that they didn't have the copyright to. So in this case, they were held to have authorized the copyright infringement of the singer because despite having the power to prevent them from performing the songs, they didn't do so. But the definition of authorization that applies from 1928 until today is that it involves sanctioning, approving, or countenancing the infringements of another. So in this case, the concert hall owner countenanced the infringement, and that counts as authorization because they didn't prevent the singer from performing the songs even though they could have. So under the Digital Agenda Amendment, which was in 2000, a number of different changes were passed to the Copyright Act that specifically changed how authorization could be interpreted by judges. And these three sections were 36.1a, 101.1a, and 112e. So you might notice that 36.1a and 101.1a correspond directly with 36.1 and 101.1. And again, they're interchangeable. They just refer to different kinds of copyrighted materials. But they state that in considering whether or not a party has in fact authorized the copyright infringements of another party, judges need to consider the power that the authorizing party had to actually prevent the copyright infringement, the nature of the relationship between the infringing party and the authorizing party, and also whether the authorizing party took any reasonable steps to prevent the copyright infringement from taking place. So specific reference is made to trade practices. So if there was something that your peers or competitors would have reasonably done that you should have done and you didn't do it, then you might be held liable for copyright authorization. Then there's 112e, and 112e is even more specific. It says that if a copyright infringement takes place, merely providing the means of communication by which this copyright infringement was able to come about does not mean that you are immediately held liable for that copyright infringement. The key word here is merely, with the implication being that if an ISP were to step beyond merely providing the means of communication, so if they did something more than that, then they could be held liable for the copyright infringements of their users. And in 2005, as part of the Australian-United States Free Trade Agreement, an even more specific set of sections was passed into the Copyright Act. And these were modelled on America's safe harbour provisions. So the safe harbour provisions are where, if an ISP is found liable for copyright infringements of its users, then it can still escape liability if it implemented reasonably a policy for managing or preventing copyright infringement. And usually, and explicitly in the case of both the American provisions and the Australian provisions that were modelled around the American provisions, this would mean banning repeated copyright infringers from accessing the internet as an ISP. So 116.A is the section that was passed, and really it's actually a group of sections. But the gist of it is that an infringing internet service provider can escape liability if they adopt and reasonably implement a policy that terminates users who repeatedly infringe copyright. So you might notice that it's organised a little bit similarly to the Electronic Commerce Directive from the European Union that we studied in Week 9, in that it distinguishes between ISPs who transmit, cache, store, or refer users on to infringing copyright materials. So effectively, they're covering the bases of the different kinds of acts that an ISP could perform, and saying that provided that in each one of these cases an ISP takes reasonable steps to implement a policy that terminates users who are repeatedly infringing copyrights, then they can escape liability. But it's worth noting that, unlike in the Electronic Directive, which specifically states that the directive does not prevent other laws from holding ISPs accountable for some kind of policy that bans users, here the exception is having such a policy. So in this case, an ISP have that, in order for this section to apply, an ISP has to have actually been found liable in the first place by other means. So this is like a get-out-of-jail-free card. So I'm now going to take you on to the facts of the case so you can understand how all of those laws that I mentioned might have applied to the situation of iiNet. So the plaintiff was Roadshow Cinemas, and in fact they were a group of plaintiffs. Roadshow Cinemas just had their name on the case. And they were a group of studios, specifically, all of whom had rights to films that had been infringed over the internet through the means of BitTorrent. And it had been iiNet users who had been using BitTorrent to infringe the copyright of these copyright owners. So iiNet in Australia is an ISP in the most traditional sense. It allows people through broadband to connect to the internet. The reason why this is an important case in many ways is because iiNet and Roadshow Films are two very recognisable parties in Australia. iiNet is a very large broadband provider, probably the largest in Australia, it's fair to say. So this was really the first time that the facts warranted the statutes that I mentioned being applied in such a wide-scale way. And it's worth noting that the liability of iiNet for the infringement of its users hinged directly on the fact that they had received infringement notices from Roadshow Films and the other parties. However, they hadn't acted on them, and instead had just passed them on to the police. So, would iiNet be held liable for not doing anything in the face of obvious copyright infringements by its users? Well, as I mentioned before, the iiNet case is in fact two cases. So the first case went to the Australian Federal Court, and as you might be aware, in the Federal Court, if you begin as a plaintiff, then you'll be seen by one judge of the Federal Court. If then you appeal the decision, as was the case in iiNet, then you go on to the full Federal Court, which consists of 3 judges. So it's worth bearing in mind that the decision at trial was a decision of 1 judge, and the decision on appeal, which I'll consider after this, was the decision of 3 judges, and was the binding precedent. So it's worth noting what the judge said at trial to give you an idea of how the laws were characterised initially, and it was held that iiNet could not be held liable for the infringement of its users. And there were 2 reasons why the judge said that. Firstly, the judge said that they could not be held liable because they didn't provide the means of infringement. So they didn't authorise the copyright infringement because theirs wasn't the method of communication by which the copyright infringement took place. Instead, it was BitTorrent who provided that. And as a result, the judge held that iiNet could never have been held liable for the authorization of the copyright infringement. So the second reason is involved the judge considering the section I mentioned before, 1011, which set out the three things that courts needed to consider when deciding whether or not a party had authorized copyright infringement. And specifically, the judge looked at whether or not iiNet had the power to prevent the infringements and whether or not they took reasonable steps. And they held that iiNet did not really have the power to do it, nor would it have been reasonable to ban copyright infringers from their broadband services, because it would have been too costly and too complex. So, in this case, whereas Roadshow Films said that iiNet should have banned users, the judge said no, they shouldn't have, and so the fact they didn't make them liable for authorization of copyright infringement. However, there was a third point that the judge made, which is very interesting. They said that, although iiNet did not have to act, they'd still received notice of the copyright infringements from Roadshow Films, and as a result, they had gone beyond merely providing the means of communication that I talked about under 112E. That meant that had they been liable for copyright infringement, 112E would not have saved them, because they were not merely providing a means of communication. So the judge was making the important point that finding out about copyright infringements, having knowledge of them, means you move beyond merely providing a service. You become something more, and that something more is what's required to be found liable for copyright infringement, even though the judge in this case said that that was not the case for iiNet. So, understandably, Roadshow Films were not happy, and they decided to appeal the decision. So the full federal court, 3 judges of the federal court, disagreed with a lot of what the trial judge had said, but they still ultimately found that iiNet was not liable. So the things they disagreed with specifically were the idea that the means of infringement was somehow relevant to whether or not an ISP had authorized the copyright infringements. They said that the means of communication was ultimately irrelevant. The fact that iiNet had not specifically provided the service by which people were sharing the files that counted as copyright infringement didn't matter, and that iiNet being a service provider was enough to hold them potentially liable. This is very confusing, but it's easy to see how the full federal court came to this decision, because under what the trial court said, it would be very difficult to find any ISP liable for any copyright infringements of its users. They also said that a system of warnings would have been reasonable, in direct contrast with what the trial judge said. So they said that actually finding a system to tell users that they were infringing copyright and threatening them with bans, and then banning them when they didn't cease the copyright infringement, would have been a totally reasonable thing to do, and that iiNet potentially should have done it. But they didn't do it and were still not found liable. Why was that? Well, it all came down to the nature of the infringement notices. So the 3 judges, or 2 of the judges with 1 dissenting, said that the infringement notices were not specific enough for iiNet to have actually acted on them by banning the users. So there needs to be more evidence in an infringement notice, or at least more evidence than Roadshow Films' infringement notices provided, for an internet service provider to be bound to actually act on it, for that to be considered reasonably acting to prevent copyright infringement. And then in Obiter, the judges made the important point that sections 116 and 112 would not have applied. So that's 112, the one I was talking about before. Again, they agreed with the trial judge and said in 112E that iiNet had moved beyond merely providing a communication service because they had received notification. But they also interestingly said that the safe harbor provisions that I mentioned before, 116A, would not have applied either. The reason they said that they would not have applied is because iiNet had never been found liable for copyright infringement in the first place under their judgment, and so there was no need for 116A to apply. But they said that had iiNet been found liable, the fact that they'd done nothing meant that 116A would not have saved them. So now we look at the meaning for ISPs. And as you can probably understand from what I've been saying, there's a lot of ambiguities in the case, but I'll talk first about what it actually gives ISPs concretely, what they can do to avoid liability for the copyright infringements of their users. So specifically, an ISP can be held liable even if they don't provide the means by which a copyright infringement takes place. So authorization has nothing to do with whether or not you directly provide the service, provided that someone is actually using, say, your broadband service to use something like BitTorrent. That could still mean that you'd be found liable. Secondly, a system of warning and banning users would be a reasonable way of complying with Section 101A. This was the first time that something like this had been said in Australian courts, so it's important for ISPs in Australia because they now know that they do actually have to have some kind of system to ban users. But a potential get-out from the case, as I mentioned, is that ISPs need only act on an infringement if it's specific enough, or if it contains enough information that they can directly act on it and ban the users. So in this case, it was too vague, and iiNet was held to have actually been correct in going to the police rather than acting on it directly themselves. However, there are a number of questions, as I've been building up to, that the case leaves for internet service providers. Specifically, it doesn't really work as a big test of 112e or 116a, because it didn't exactly set out when the exceptions would apply. So the case has obviously talked about how iiNet could not have applied 112e as an exception because they went merely beyond providing communication for users. But neither case really set out what that communication would actually look like. So what merely providing communication would actually mean. It merely set out what it means to go beyond merely providing communication. It also didn't really explain how 116a would apply in any situation. It mentioned that iiNet would not have been able to use 116a because they had not implemented a system by which they could ban users at all, which is what 116a requires. But they didn't really talk about what kind of system would, in fact, be acceptable for the 116a exceptions to apply. So ISPs in Australia really have no idea what the safe harbour looks like. They merely know what it doesn't look like. And it's fair to say that most ISPs before this case would have been able to guess that doing nothing, as iiNet did, would not amount to a safe harbour exception. And secondly, the case only half clarified how much weight should be given to the factors listed in 101A. So both the trial judge and the full court, the Federal Court of Australia, did consider the factors in 101A, specifically the power that iiNet had to prevent copyright infringements, and whether they took any reasonable steps to prevent copyright infringements. However, although there were differing opinions on between the trial judge and between the full court on whether or not these factors had in fact been met. So the trial court felt they had been met and that iiNet could not have taken reasonable steps, and the full federal court said that in fact they should have been met because it was reasonable for iiNet to take steps and they did have the power to do it. But yes, both courts came to the same conclusion, that iiNet wasn't liable. And one of the criticisms that's been made of 101A, 101.1a and 36.1a is that it doesn't really set out the extent to which courts have to take in the three factors when considering whether or not a party has authorised copyright infringement. So really, it still leaves a lot of ambiguities for ISPs. They really don't know the extent to which the exceptions would apply to their behaviours, and they really don't know the extent to which the power they have to prevent copyright infringement, the relationship they have with the copyright infringers, and whether or not they've taken any reasonable steps to prevent the copyright infringement. They don't know to what extent any of these will be taken into account when a court considers whether or not they've authorised the copyright infringements of their users. So thank you so much for watching. I understand that you had to take time out of your day to do it, and thank you for being willing to accommodate me even though I didn't show up that one Sunday in week 1. And also, since I suppose this is the last time we'll be seeing each other face to face, thank you for the course. The Swedish flag was the most inviting thing I could think of for the background. I had a really great time, and I actually learned a lot of things that I wouldn't have had any other reason to learn. So thank you for a great course, and I hope you enjoy your Christmas all.